Hello friends, today I'm at the Telangana High Court. I came to file a rejoinder in a criminal revision case. So let me tell you what criminal revision case is all about. Criminal revision is like a kind of appeal wherein you go for a challenge of a magisterial order. Either you can go into the Sessions Court or else to the High Court of Judicature. So this is maintainable on 397 as well as 401 of CRPC, and you have only one opportunity to file a revision petition. This is available normally for the complainants, and I have filed a criminal case under sections 420, 406, etc., etc., against property fraud against some people, and they have managed the police, and the FIR was closed. And thereafter, the magistrate also, after recording the statements, have dismissed the protest petition. So therefore, I came for a revision to Honorable High Court of Telangana. And let me tell you what are the important ingredients when it comes to the criminal revision. First, there are three ingredients which are very important. First one is called correctness, and which is basically depends on the factual matrix, whomsoever is considered to be appropriately correct. And if facts are in your favor and the adjudication is done adverse to you, then you can always claim this point of correctness. Then comes the legality, and last thing is judicial propriety. So now let me tell you what correctness, on what grounds of correctness I'm urging. So the court below has not considered the documentary evidence, statements of witnesses, and wrongly jumped into the conclusion on a wrong ground. This is for the correctness. As I told you, it depends on the facts. Second one is legality. So let me tell you a few of my grounds. Violated the section 200 and 202 of CRPC, which are statutory rights and provisions provided to the complainants for privately prosecuting the accused if police fails them. Okay, so if police or if police fails you, then you always have a statutory right to move the magistrate's court under 200 CRPC and to privately prosecute the accused, all right, without any need of a public prosecutor nor any kind of interference with the police. Straight away, if you have the evidence, you can always do that. And the next ground is violated section 190 CRPC. Cognizance has to be taken if prima facie case is made out and charges to be framed under section 240 CRPC. So in this particular case, the magistrate has not taken cognizance, wherein the prima facie case has already been made out. Why? Because this was a case already referred by the magisterial court to the police. The FIR was registered upon the directions of the Honorable Trial Court. So once the prima facie case is made out, then the police will register an FIR and direction will be provided to them. Then they will register an FIR, and after that, if they close it, then you come for a if they close it wrongly, then you come again with a protest petition. Then the protest petition has to be accommodated. So in this case, it was rejected on the ground stating that there is no prima facie, which is wrong. A particular court, the same court cannot talk in two tongues with two different versions. So one says its prima facie case is made out, and again it says prima facie case is not made out. That's wrong. And next, under section 3 of the Indian Evidence Act, this is the evidence part. With documentary evidence and the sale deed is incriminating evidence which proves both fraud committed by the accused and wrongful gain made by them. And also section 65B, it falls under electronic evidence and need not be proved by any oral evidence. If you have a document, then it need not be proved by oral evidence. This is what the Indian Evidence Act says. Okay. And under section 8, motive is established as the only goal of the accused was to defraud their own siblings and immensely gain from the commission of the offense of cheating and criminal breach of trust. And then comes under section 6 of the Act, that is Indian Evidence Act, the witness statements are valid as they are part of complete transaction and commission of the offense. All right, so they are all res gesti witnesses. Okay, res gesti means who complete the transaction. So the last ingredient what I told you for revision is propriety, that is called judicial propriety. So here the ground was the same court below cannot give two contradictory orders in the same case. Initially, while referring the private complaint, cognizance was taken, prima facie case was established, and the same court below, while dismissing the protest petition, says no prima facie case is made out, which is wrong. Then comes the binding precedents, and various honorable Supreme Court judgments are violated, which are law of the land as per Article 142, 141, 142, and 144, and binding on the courts below. They are called binding precedents. It was held by the Honorable Supreme Court in Vijay Kumar Ghai versus others, and that for the IPC 420 to attract ingredients of dishonest inducement, delivery of property, and wrongful gain need to be established, and for the criminal breach of trust, misappropriation of property needs to be established, and these were established. And as per SC judgment in AR Antole versus State of Maharashtra, Section 200 CRPC is a statutory right of the complainants to privately prosecute the accused if state fails them, which I already told you. And if prima facie case is made out, charge sheet has to be filed, and trial has to take place as per various honorable Supreme Court judgments in Sajjan Kumar versus CBI, Union of India versus Prafulla Kumar Samal, Dilawar Balu Kurane versus State of Maharashtra. These are all landmark judgments. It was held by the honorable Supreme Court in Uma Shankar Gopalika, which is also a landmark judgment. For cheating to attract, intention to cheat should be established right from the inception, and in the instant case it is proved by documentary evidence of a release deed. So my dear friends, I hope I've appraised you about the three important ingredients for the criminal revision cases. So you only have one opportunity, which you need to put it to the best use and get the best output, or you need to succeed. So you don't have a second chance when it comes to the criminal revision. But if it's an appeal, you have many chances, but not for revisions. Okay, my dear friends, thank you so much.